Assistant Public Defender on behalf of Hannah Apple on behalf of Mr. Simmons. You say your name for the record?
D'Angelo Simmons. Yeah.
This is a competency.
Is the report back?
Yes,
Judge?
the report is
Okay.
back. It's dated August 19. Don't know why. And it is finding that the defendant is competent to stand trial.
We would stipulate to that report, Your Honor.
All right. Court, having reviewed that report, would find the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I do have an order that was submitted by Mr. Brown to that effect to the court, or proposed order. I'll sign that. Would you like this? Would you like this now set for?
Your Honor,
Oh, you're back.
Oh, hello.
No,
Lauren Brown,
it
Deputy
was
Chief.
more of a pleasure dealing with Apple, but go ahead.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Simmons. Your Honor, we are respectfully requesting this matter be set for probable cause conference so that we can have some kind of substantive conversation with our client.
Is this the only thing holding him, or is he?
I believe it's the only case.
This is the only case.
Okay, so I'll set it for the 18th,
Thank you very much.
September 18th, 2025, 9 a.m. Bond continued.
Thank you.
You saw that, lady. Court does call the case, People versus Dale Miller.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Miller, who appears by video. Mr. Miller, could you please state your name for the record?
Dale Joseph Miller, the Alpha and Omega.
Okay. That's
Your Honor, the reason we are here today is this was set for a probable cause conference. However, Mr. Miller is undergoing competency evaluation and other matters.
what? No, go ahead.
So we
Oh, you
know-
guys can find out it's not
I'm
so
in-
funny pretty soon.
I am informed of that. And we have, is there a competency order for this file?
yes,
Yes, I do have it. All right, so what I will do
On
is
top
I
of
will
things.
order competency on this file. I will set it, I think those are set for November 6th.
yes. So we'd ask Mr. Miller, just as we spoke, we're going to ask that this matter be joined with the other matters.
So I will set this for November 6th, 2005, 9 a.m. This time his bond will continue. Thank you.
Thank you very much, Your Honor.
Court calls case of the People versus Kevin Burton.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Burton, who approaches, Your Honor.
Kevin Burton, sir.
Thank you.
And Your Honor, today we'll be entering a plea. I believe the court is in receipt of everything that it needs to have.
Let's see. Yes, I do have it. All
And I
right,
apologize, there is a adjournment sheet there as well.
That's okay. I have a plea form that indicates that the defendant would be pleading guilty to the charge of aggravated assault, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, and that the prosecutor will be recommending to the sentencing judge, prosecutors deferred.
Power move. She opposes the reset. In family court, delays can feel like control tactics, especially when an MDA clocks a hard 90-day deadline. Have you ever seen a delay used as leverage?
That's the court's full understanding.
That is our full understanding as well, Your Honor.
All right, may I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Kevin Burton, sir.
Sir, it is this court's understanding that you're going to plead guilty to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You
Yes, sir.
understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, sir. Yes,
Plead guilty
yes, sir.
to that charge. How do you plead?
Guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
My attorney has. I signed it with his permission, Your Honor.
All right.
Yes, sir.
You went through that advice of rights form, is that correct?
Yes, sir.
All right. You have any questions regarding any of those rights?
No, sir.
Please look at, there's a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of the court.
I do.
You understand you're giving up your right to appeal, all right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes. Or no. No, no one's promised me anything.
All right, let's get that straight. Has anybody promised you anything else other than what's been stated here today on the record to get you to plead to this charge?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes, sir.
of your own free will
Of my own free will, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On July 13, 2024, at the location of 3421 Platte Road, Apartment 12, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do on that date involving an Angela Middleton that makes you think that you're guilty?
Threatened her, sir, with a hammer, sir.
Okay, you had a hammer in your hand?
Yes, sir.
And you were in close proximity to her at that point?
Yes, sir.
And you threatened her with the hammer?
Yes, sir.
Did you say something that threatened her with the hammer?
Yes.
What'd you say?
Cannot recall, but I said something threatening.
You said something that led her to believe that you would use that hammer
Yes, sir.
against her.
Yes, sir.
Would that be correct? All right. Either way. Sir, I would have to advise you that after I accept your plea and after that time, between that time and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and you also the court would not be bound by any sentence or agreement or evaluation. Do you understand that, sir?
I do.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
September 23rd at 9 a.m.
September 23rd, 2025, 9 a.m.
No show? Bench warrant drops $10,000 cash bond. That's the court saying, skip again, and you're not walking out unless you pay hard money. Fair warning, judges don't play around with attendance.
That's before Judge Valvo. Bond will continue.
Thank you very much, Your Honor.
Court does call the case People versus Catherine Stiles.
Jackie, Assistant Public Defender, with and on behalf of Ms. Stiles, who is approaching.
Name?
Catherine Stiles?
Thank you.
And Your Honor, I do have a stipulation and proposed order for release to treatment for Ms. Stiles with the tether. The prosecuting attorney did indicate that she would stipulate if Ms. Stiles was released to treatment with the tether. Absolutely. Yes, sir.
All right.
Sorry, as to the substance of the PCC, I did not fill out a green sheet because Ms. Stiles wanted to request that this matter be continued to exam. However, and when I inquired yesterday, I think there wasn't media discovery. There may or may not still be outstanding discovery. So that's where we're at.
So our office did request the police on August 27th video. They hadn't provided it to us, and they've not provided us any video. But there was an officer who responded to a store, and so I'm just going to confirm that there's no video there. But we did ask.
All right. You would not be entitled to an adjournment if that existed not. You understand that, ma'am, if you want to proceed to exam?
Because the prosecuting attorney has given us all the discovery they have, if there's something else, we can't ask to adjourn it because at this time we're saying that that's all they have. Does that make sense?
Yeah, absolutely.
People have their witnesses available to 16. Preliminary examination will be set September 16th, 2025. Judge Washington. Bond will continue.
Thank you, Your Honor.
Possible before the 16th?
Thank you.
Whoa. This is. Where's the gas? This is the gas station? That's the part. They're not attached.
Your Honor,
There's a road in between,
my
like
client
a
is
big
not-
road.
My client is not as eloquent as you, Your Honor, when it comes to describing things. Now, we could get her some writing classes so she can learn to paint word pictures, but it is on West.
Hold on a moment. No. You're a very good attorney. You are not going to spin this. She told me the Walgreens, and it's not a Walgreens, it's a CVS.
I mean, she did say it was possibly a CVS, though.
One's red, one's green. Okay. She said the gas station was attached to the Walgreens.
Well,
There's a road.
maybe it just got built.
No, there's a road.
Is it a newly paved road, Your Honor? It's a brand new road.
Here. No, I'm not recalling it. You can let your client know. I did look at the map.
Yes.
Story still doesn't make sense. Her motion for bond reduction still denied.
Thank you.
But thank you for the pictures.
Thank you.
I would have done the AI, Mr. Brown. Court calls the case People versus Montez Miller.
Assistant Public Defender Jay Bellinger on behalf of Mr. Miller on case ending in 1435, Your Honor.
And Edward Lucas on behalf of Montez Miller in 1434.
You both are requested. And your name, sir?
Montez Miller.
Thank you.
Your Honor, I did be put before the court an order for release to treatment. I'm hoping that the court will sign that so that he can find a bed as soon as one becomes available. Otherwise, we don't have any discovery on this case, so we'd be asking for an adjournment.
I'm just asking for an adjournment for video purpose.
Get these together. Is this the only thing holding him?
I think there's some nominal bonds in these two cases. I think there is a circuit court case that
He's got a violation up in circuit.
Got it.
Sir.
Probable cause conference, September 25th, 2025, 9 a.m. Bond will continue.
And Your Honor, as to the order for release to treatment.
Oh, I'll sign the one that Mr. Drukas. I'm not signing it. No, I'm kidding. I signed them.
Thank you.
appreciate it, Your Honor.
Thank you.
All right. Thank you, sir.
Okay.
I want everybody to drive around and I will call somebody's cases. I'll give somebody a reward where there's a pharmacy hooked to a gas station. If somebody shows me one of those, I'm just thinking, those seem like two incompatible uses, but maybe I'm wrong. Court does call the case of People versus Tiffany Cash.
Assistant Public Defender Alexis serves with and on behalf of Ms. Cash and should be present via Zoom.
Bless you. Ms. Cash.
Continuance granted because counsel's out of state. Judicial Etiquette 101. courts avoid sandbagging a party when their lawyer can't appear. Quick check. Should there be hard limits on last-minute?
Perhaps she got up to use the restroom, Your Honor. Ms. Cash, can you please unmute and state your name for the record?
Think she can hear you in the restroom or what?
Your Honor, may we briefly pass this?
You enacting ruling, you're pushing it. Court does call the case, People versus Justin Straight. And I've got a DOC.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Straight, who approaches. Mr. Straight, can you please state your name for the record?
Justin Straight.
All right.
And Your Honor, I am asking for an adjournment. Although we are now in receipt of the media discovery, I have not had time to go over that with my client. However, I do understand that the court did sign an order for release to treatment over the last few days.
Yes.
Please.
He did. Okay. So they have it already, so they're gonna get it. Okay.
So I can get in?
Yeah.
Thank you. Got it.
Very good. I'll bring it.
So this is the only thing holding, well, he's got a bond violation on this one, but this is the only thing holding him.
As far as I know, Your Honor.
Probable cause conference, September 25th, 2025.
You should be in it. You should be 9:25.
Bonds
Should be in
continue.
bed by then. Okay.
Thank you.
9:25 is your next day.
I'll be in bed.
You should be in it.
Court does call the case, People versus John Coffey. Pardon? Mr. Coffey?
Yes, sir. Sorry about that, sir.
All right.
Did the prosecutor, okay, can I on behalf of Mr. Coffey? Mr. Coffey, can you please state your name for the record?
John Joseph Coffey Jr.
I have before me the two files that he is going to be pleading guilty to the charge of retail fraud in the third degree on each case.
That's correct, Your Honor.
That's correct, Your Honor.
That's the court's full understanding of the. Mr. Coffey, can you please raise your right hand?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
John Joseph Coffey Jr., sir.
All right, you can put your hand down. Sir, starting in case 25-1118, says court's understanding that you're going to need to be someplace stable, sir.
Yeah, I'm stop moving. Sorry about that, sir.
Maybe you could sit down, yeah, or stop walking.
All right.
Thank you.
Sorry.
Starting in case ending in 1118, it says court's understanding that you're going to be pleading guilty to the charge of retail fraud third degree. And likewise, in the other case ending in 1272, you're also pleading guilty to the charge of retail fraud in the third degree.
Yes,
Those
sir.
are misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Sir.
You understand that?
Yes, sir, I do.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
Again, starting in 1118, to the charge of retail fraud third degree, how do you plead?
Guilty, sir.
In case 1272, to the charge of retail fraud third degree, how do you plead?
Guilty, sir.
All right, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I gave my lawyer permission to sign it.
And you went through that advice of rights form?
Sir.
Do you have any questions regarding any of the rights contained on that form?
No, sir.
All right. You understand that you'll be giving up your rights, specifically the trial rights defined or described in paragraph 5.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are guilty of this offense in these cases?
Yes, sir.
Starting again in the case ending in 1118, on the date of April 2nd, 2024, at the location of 1103 South Main Street, City of Chelsea, Washtenaw County, State of Michigan, what'd you do at the Ace Hardware that makes you think that you're guilty?
I took some power tools that were for sale from the public and went past the point of sale.
Okay, so you went in, got power tools, tried to walk out of the store without paying for them?
Yes, sir.
At the time, was the store open to the public at the time?
Yes, sir.
Did you have anybody's permission to take that property?
No, sir.
And this was property that was offered for sale by Ace Hardware?
Yes, sir.
In the other matter, 1272, I can complain on that. Give me one. All right. In that case, on the date of February 25th, 2024, at the location of 5645 Jackson Road in Scioto Township, Washtenaw County, State of Michigan, what did you do at the Meyer that makes you think that you're guilty of that offense?
I went in the store to try to take merchandise that was for sale.
All right. Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property, did you?
No, sir.
And the property you took was property that was offered for sale by Meyer?
Yes, sir.
Sir, I do have to advise you that if I accept your pleas on these cases and you commit misconduct as defined under the Michigan court rule between the time of this plea and the time of your sentencing, you would not be the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir, I do.
You also understand you would not be entitled to withdraw your plea.
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to these pleas?
No, Your Honor.
I didn't hear a prosecutor. Ashley.
No, Your Honor.
All right, and has the court complied with the court rule and would it be proper to accept its defendant's pleas?
People are satisfied.
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to count 2 in each of these cases. Count 1 in each case is dismissed. A pre-sentence investigation and report is ordered at 1483 probation. Sentencing in these matters will be set for November 3rd, 2025, 9 a.m. before Judge Freshow.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank
Bond will continue. Thank you, sir.
Thank you.
Case of the people versus Delco Thomas.
Alexander on behalf of people.
Lauren Brown, Deputy Chief Public Defender, appearing written on behalf of Mr. Thomas. Mr. Thomas, please state your name for the record.
Delco Thomas. Thank you, sir.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
All discoveries complete.
Best of our knowledge, Your Honor.
People have their witnesses available to 16.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That is before Judge Perry.
Let's do this.
Bond continued.
Thank you very much.
Thank you. Court calls case People versus Alicia Cargill.
Good morning, Robert J. Kilwall on behalf of Ms. Cargo. Ms. Cargo, would you state your name for the record?
Alicia Cargill.
Thank you.
Your Honor, here's where we stand on the situation. I met with Ms. Cargo at the prison on August 20th. We went over the police report. Co-defendant that previously pled to a misdemeanor. I believe I was offered that. Ms. Cargo wants to see the video of the incident. I have to make special arrangements with the prison in order to bring a computer into the Huron Valley prison. I need more time. I'm asking if I could have 3 weeks so I could make those arrangements.
I will cause conference without objection. Will we set October 2nd? No, I don't have the October 2nd date. Right. I don't have October 2nd, so I meant September 30th, 2025 at 9.
Thank you, Judge.
Thank you, Bond. Continue. Court does call the case People versus Brandon Jackson.
Good morning to this honorable court. Carla Marable, P number 6755 on behalf of Mr. Jackson.
Your name?
Brandon Jackson.
Thank you. All right, what are we doing on this case?
Your Honor, I am now in receipt of discovery. There's a co-defendant in this case, and I'm representing him too. They have waived conflict. We're asking that it be set for a preliminary exam.
Who is the co-defendant?
He was up last week, Your Honor.
When did we set the? When did we set the?
Jackson. We haven't set one yet.
When did we set that preliminary examination?
Your Honor, I'm not seeing that it was a separate exam. The note that I have, I wasn't present for that, but I see that it was adjourned for a probable cause conference on the 11th.
Okay, so you want this one set for exam, and then next week you're gonna set the other one?
Correct, Your Honor, and I apologize for interrupting you. I'm so sorry.
No,
Yes.
it's okay.
Yes,
Okay.
because at the time, we didn't have discovery, but we have discovery now. It was sent out late yesterday.
Okay, did you wish these, or is there gonna be a problem if they're heard on the same day?
I think that the prosecutor's gonna want them on the same day, Your Honor.
That's nice of you to concede to what they want. I've never seen that before.
But I mean, I prefer for them to be on the same day. I think it.
Yes, all right, very good. Yes,
I was going to say it would work if they're on the same day, but I'll defer to the court.
all right. And both individuals are in custody?
Yes.
All right. Well, I guess I could set them for the 16th. And then that other one, that would just be short notice, but you'd have to let me know to set it for the 16th so they don't remain in custody. Will that work for you, counsel?
No, I start a trial on the 15th.
All right. My next day, then it's the 23rd.
That
I have
works,
the
Your Honor.
the 23rd will work?
Yes.
Okay. So I will set preliminary examination in person, September 23rd, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you. Bond will continue in this case. Thank you. Thank you, sir. Thank you. Court does call the case People versus Jermaine Dalton.
And then on behalf of Peter, Your Honor.
Brian Bowling on behalf of Mr. Dalton, just state your name for the record.
Jermaine Dalton.
Thank you.
Your Honor, we're asking this matter be set for an exam. I believe all discovery to be complete.
And would the people have their witnesses available the 16th?
We'll do our best, Your Honor.
Paperwork, yeah. Preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus David Davis.
Mayville for the people, Your Honor. Public Defender Hannah Apple appearing on behalf of Mr. Davis. Mr. Davis, will you state your name for the record?
David Davis.
Thank you. Your Honor, I am asking for an adjournment for plea negotiations, and I do have information regarding the bond violation that I want to address with the court.
Yes.
Okay. Your Honor, I did receive that yesterday. I contacted Mr. Davis. We went through that. I will note he's on a scram tether. My information that there's been no violation. I, of course, assume that the court's biggest concern is this positive test for cocaine. The first one, Mr. Davis is forthcoming. I mean, he does not disagree that both tests are positive for cocaine. He does not deny use prior to being arraigned. But of course, that second test on the 21st is of issue. Mr. Davis is taking this matter very seriously. He is employed. He did reach out to Dawn Farms yesterday to enroll in outpatient treatment. I did provide documentation to opposing counsel, confirming that he did a screening and confirming that he is scheduled for his assessment on Friday, September 12th at 11 a.m.
But he doesn't have a medical marijuana card either.
No, and he reports that he has stopped use. I don't know. I think that's roughly like 3 weeks. I don't know if that's, or maybe actually less than, yeah, about 3 weeks if that is still in his system or not. But he reports that he has stopped THC use. But I think at this point, he at least, I would point out that he's had at least one test that he did not test positive for cocaine. He's on the scram tether, confirming that he's had no alcohol use. And he's working on getting into treatment and doing the right thing and showing the court that
But he's not in treatment.
he has intake scheduled for the 12th. He did an assessment yesterday. He's beginning outpatient on the 12th this next Friday.
I
September
will
12th.
adjourn his probable cause conference to the 11th, 2025, 9 a.m. But prior to his intake, defendant's remanded to the Washington County Jail. Bond is revoked.
Understood. Your Honor, would you like a copy of the confirmation of his treatment for the file?
Why don't we bring that up on the 11th?
Okay,
Okay, because I just don't want to keep it in here. if
Sure.
I don't have.
I'll do that. Thank you, Judge.
Court calls the case of the people versus Enrique Davis.
Alexander on behalf of the people.
Ready, Judge? Court shall feature Assistant Public Defender on behalf of Mr. Davis, who is approaching the podium. Mr. Davis, please state your name for the record.
Eric Davis.
Thank you. Thank you, Judge. I have had a chance to email the prosecutor and fit Mr. Davis. He is hopefully get this matter resolved, but he is not quite ready yet. We're still negotiating a resolution. May we have a 2-week adjournment?
Probable cause conference will be adjourned to September 25th, 2025, 9 a.m. Bond will continue.
9 a.m.
Yep. Sign up. Court does call the case of people versus Rayshawn Dawson.
I read that on behalf of Mr. Dawson. Can you continue for the record?